So you've got a brilliant idea, something you think could really change things. But how do you actually protect it? Well, today, we're going to break down the first crucial steps of filing a patent in India. And we're getting our info straight from the source, the Patents Act of 1970.
Here's our roadmap for today. First, we'll figure out who can even file a patent. Then we'll look at the essential paperwork you'll need. We'll also explore a really key strategic choice you'll have to make, get into the details of describing your invention, and finally, we'll lock in why securing something called your priority date is just so important.
All right, let's get into it. It's time to turn that game-changing concept of yours into a legally protected asset.
Okay, first things first. Before you even think about filling out a single form, we have to answer a really fundamental question. Who is legally allowed to apply for a patent in the first place? Thankfully, Section 6 of the Act makes this crystal clear. The law basically points to three specific groups. First, and this is the most obvious one, is you, the true and first inventor. Second, it could be an assignee, maybe your employer or a company you've sold the rights to. And third, if an inventor has passed away, their legal representative can step in and file. And just remember, any of these folks can apply on their own or even team up and do it jointly.
All right, so you've confirmed you're the right person to file. Awesome. Now, what exactly do you need to submit? Let's dive into the nitty-gritty of the application itself, which is all laid out for us in Section 7.
And here is a golden rule you've got to remember. One patent application, one invention. Period. This keeps everything clear and focused for the examination process. So let's say you've invented both a new software algorithm and a new type of bicycle lock. Well, you're going to need two separate applications for that.
So your application has to tick a few key boxes. You've got to use the official form, you need to state that you're actually in possession of the invention, and you have to name the true inventor, even if you're an assignee filing it. And crucially, you must also include something called a specification, which is basically the detailed description of your invention.
Now, this brings us to a really major strategic choice you have to make right at the beginning. You need to decide, are you going to file a provisional specification, or are you going all in with a complete one? Section 9 of the Act lays out these two different paths.
Let's use an analogy here. Think of a provisional specification as a detailed sketch of your idea. It's less formal, but it's perfect for securing an early filing date and establishing your priority. The complete specification, on the other hand, is the final blueprint. It's the fully detailed document that gets examined and has to explain exactly how to replicate your invention.
And this is a deadline you absolutely, positively cannot miss. If you start with that sketch, the provisional application, a clock starts ticking. You have exactly 12 months to follow up with the blueprint, which is your complete specification. And what happens if you miss it? Well, the consequences are severe. The law is really unambiguous here. If you fail to file that complete specification within the 12-month window, your application is just considered abandoned. You lose that early filing date and all the protection that came with it.
Now, whether you're filing that initial sketch or the final blueprint, the absolute heart of your application is the description of your invention. Section 10 tells us precisely what's required, and believe me, the standard is high.
Yeah, the Act does not mince words. You have to fully and particularly describe everything. It's not enough to just say what your invention is. You have to explain how it works, how to use it, and the method to make it, all in enough detail that someone who's skilled in that field could actually replicate it.
So your complete specification, that final blueprint, it's got to have several key parts. It needs a title, that full description we just talked about, and, this is important, it must disclose the absolute best method you know of for carrying out the invention. Critically, it has to end with claims, which are the precise legal sentences that define the boundaries of your protection. You'll also need a technical abstract and any drawings that are necessary.
We've mentioned this a few times now, but let's really focus on it. Why is filing early so incredibly important? Well, it all comes down to one of the most powerful concepts in patent law, the priority date. And this is all detailed in Section 11.
So what is it really? Simply put, the priority date is the date the Patent Office receives your very first application. Think of it like getting a timestamp. It's your official place in line. In the world of patents, being first is a very big deal, and this date is your proof of exactly when you got there.
And this is where the whole strategy just clicks into place. On day one, you can file a provisional application, that quick sketch, and immediately lock in your priority date. This gives you up to 12 months to keep developing and refining your invention, all while knowing your filing date is secure. Then, when you finally submit the complete specification, its claims are protected all the way back to that day one priority. It's a really powerful tool for inventors.
So there you have it. We've covered the who, the what, and the when of filing your patent in India, all the way from identifying the applicant to securing that all-important priority date. Now that you have the map for the journey, what's the first step you'll take to protect your invention?